Hi guys, it's Kathy. I hope you're doing well. We made it to Monday morning. We have got a heck of a long work week coming up. I don't know how else to say that, but that's good. It's better than not having a job, right? So, I'm bad. We got 8 weeks off with 1 day snuck in there. There's a special show. But that's going to be a lot of videos. A lot of court. It's going to happen in those 8 weeks, guys. We're going to have some good stuff coming in a week. Next week. Plus it'll be Furman Tape City on OJ. Next week is going to be great. But today's going to be great too. Don't worry. I got Boyd from a bit ago. This wasn't recent. There's the defendant in front of her that attacked a judge, assaulted a judge. I don't think she knew she was a judge when she assaulted her. But that was a shock. And then Kim Blandino. Now I have to talk about him first. Oh boy, I don't even know where to begin. Let's begin here. If you do not know who Kim Blandino is, if you have not seen his clips, he is quality content. High quality, must watch content. If you watch court videos, you have to watch Kim Blandino. You can watch him a couple places. But Law Talk with Mike did it best. Hands down. He did it best. And I even think he had Kim Blandino on his channel. Like, I say partway through because there's no end to his cases. And he's sort of like, I don't want to say he's like Michael McDonald, but there's no end to his cases, and he's spent time in jail for it. And he's special. But this is why I'm playing Kim Blandino today. No, absolutely not. We are not covering it. We are not going through the videos. We're not. Hard stop, period, drop mic, whatever. I am on time, exactly on time. But we are doing a snippet today, and here's why. I don't know if you knew this. Not very many people do know, because he only has 49 subscribers. But Kim Blandino has his own YouTube channel where he uploads clips of his court cases. And he made a short. He made a short of him carrying a sink into a courthouse, just like Elon Musk did. That's why I think it is actually his channel. It's just called Kim Blandino. Has 49 subscribers. But I think it's his channel. I think it is. Maybe it's not. You know, the internet, you can't tell a lie from the truth. You can't. So, maybe someone created this, but that short is what got me. Because he is recording himself carrying the sink into the courthouse. So if that short wouldn't have been there, I would have thought someone made a Kim Blandino channel and just put a couple of videos on it. I don't think so. You can also watch Kim Blandino through our Nevada judges, of course. Excellent channel. High quality. Every video. High quality content. So Mike did it best. Law Talk with Mike did it best. But our Nevada judges, high quality. They bring us so much good stuff. But we're not doing either of those. We're doing Kim Blandino's clips. He has exactly 6 videos. And they're all real short. So I just stitched them all together. We're going to watch them here. The reason why is, though, he had uploaded a video 12 days ago of a case that was from December 2nd. So it was very recent. So that's new. So it's sort of an update for some of us and a tiny taste for others who have not seen Kim Blandino yet. But first, let's do Boyd. Let's stop. Oh, that's just not Boyd, is it? Is that Boyd? No. No, it's not.
Javier Oliva and Bradley Bellis for the defendant.
Are you Gracie Saguna?
Yes, ma'am.
All right, according to the plea bargaining agreement, punishment is to be assessed at 7 years in the prison. There's a $500 fine. The state is opposing your application for deferred adjudication. They're recommending community supervision, and there are items to be taken in consideration. Have both parties had a chance to review the PSI report?
Yes,
Any objections to the PSI report, state or defense?
Judge, so there are some errors on the PSI report that we wanted to bring to your attention.
Yes.
So it lists the offense date as, I believe, November 16th of 2021, when in reality, the offense date that's on the indictment is October 16th of 2021.
All right.
And it lists that in the criminal history. There's an assault that was in the criminal history that it makes it seem as if they're 2 separate offense dates.
Okay.
And then I think in the towards the back of the actual statement itself that Ms. Seguno gave, there's a portion where it's talking about the co-defendant and that he's charged with ag assault deadly weapon. It's assault SBI. It's the same offense.
Okay.
We just wanted to make sure you were aware.
All right. And the court is also in receipt of victim impact statement. And the court reviewed that without objections from the state or defense. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And the court is also in receipt of letters that defense presented on behalf of the accused. And there were no objections to the court reading those letters. Is that correct, state and defense?
No objection, State Judge.
All right. So the court has reviewed all of those documents.
Your Honor, I also raised that the part of the agreement of coming back today was that the misdemeanor occurred on the same day of this alleged date. Was to be taken consideration with CC County Court 4 case 69-3701.
Yes. And the court does have that as a part of the plea bargaining agreement.
And Judge, just to kind of expand on that, I believe as an additional part of the plea agreement was that she was to take responsibility for what happened as a part of the TIC.
Yes. Okay. All right. So my understanding, the complainant in this case is Rebecca Martinez.
Yes.
All right. And is that the Rebecca Martinez who's on the 4th court?
Yes, Judge.
Yes, sir.
All right.
President of the courtroom.
So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues. And when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No, Your Honor.
Defense?
Your Honor, I have all the confidence that was fair and right in this case. So no objection.
All right. So are there any witnesses that anyone wishes to present, state?
So the state doesn't have any witnesses. The main thing that we wanted the court to be aware of was the statement from the complainant,
All
which the court has already noted that they read.
Yes. Defense, any witnesses?
Your Honor, other than my plea to you and our arguments to you before considering sentencing in this matter, I will be speaking and Ms. Seguno may say a couple of words. And Ms. Seguno's parents are present in support of her today. They can stand with Mr. Standing here in support of her today.
All right. Thank you.
They will not be speaking.
All right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Gracie Segunda.
All right, and with regards to County Court Cause number 693-701, the state is taking that case into consideration, but to that case, how do you plead?
No contest, sorry. I'm just so nervous.
That's okay. So in order for me to take that into consideration, she will have to accept full responsibility for it. So a no contest plea, I can't accept that because I don't have any police reports in regards to that. So she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court and the court will sign that. I don't know if you want to discuss that with her.
We'll go ahead and proceed with a guilty plea, Your Honor.
All right. So the County Court Cause number 693-701, how do you plead to that? All right. And state, do you have the dismissal
Yes,
for the
Judge.
court in that cause number? All right. So the court then will hear argument. State, you're opposed to deferred adjudication?
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. There was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that date forward, and she still feels the impact to this day. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense?
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant.
Monica, thanks for the
penalty.
cheers.
But Ms. Segundo, I think, has demonstrated a respect not only to others, but to life and to animals, and her work and her career and taking care of pets. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in their school activities and support their activities with FAA. And a felon cannot be associated with children and be around them in school activities. This would drastically impair her ability to be a mother to her children. And so she's really fighting to be able to continue to provide the love and the support of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She leases a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years this week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She has appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial, but to put the decision on deciding her future on you. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think that you're not going to be subject to conviction, but in actuality, you are subject to all the conditions and behaviors for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life or who she is or how she is as a mother or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe.
See, this proves something I didn't know was true. after a football game in Texas, when everybody's inebriated, there are consequences to actions. I didn't know that was true.
Believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court and gets justice.
Kind of, sort of, sir. Okay, kind of, sort of. I do believe if you attack a judge, you should get the heaviest book thrown at you at all possible. However, if that person is not wearing robes, not on the bench, a stranger in an elevator, then you don't know it's a judge. So, not the strongest book absolutely possible, but she did, in fact, attack a judge in an elevator. So, that's only if they lose.
Because she
Maybe.
should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of, it was just something in a reaction and defense of someone that she was with. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case, I think we've agreed to, that was presented before the court, was $2,416.29. We fully agreed to repay that. We will work hard every day to pay that back. But in this working community in Houston and San Antonio, mothers every day have challenges. And we regret that this happened. And I know that she sincerely, I have nothing personal against Ms. Martinez or her husband. She wants to do what's right, but she also wants a chance, Judge. And I'm asking you with all the fiber of my body to give her that chance. And I will make sure and work with her that she will comply with every condition, so she will never be back here before you regarding any violation or any condition of this case. You want to say something?
Nervous.
All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I've always reread everything and reread police reports and the PSI report, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean, it just, I couldn't tell you.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator.
Mhm.
Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity, people need to get off or more people can't come on, how that ends up in a fight.
Yeah, I couldn't tell you how it started. I just, somebody in my party was getting into it and somebody hit me and I just reacted. And unfortunately, I feel bad and should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit, and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight, and then you decided to get involved in that fight.
You know, I went to go and try and pull my friend away, and then, you know, like I don't know, it was just a bunch of people, and somebody hit me, and I just reacted.
Your Honor, if I could clarify, I think the facts is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they were limiting it to 7. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity. They were in the elevator, they were asked that there was too many in the elevator, and then people had to decide who's getting off, and they asked who she was with, another man and another person, to get off the elevator. That person said, I want to talk to your supervisor. That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor. She came in assistance to that man, and that's when she was hit, and that's when she struck the victim. That's stated in one of the reports here that was provided to you in the PSI. And she did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off of her friend. And
2 trips.
in the process of that was struck and she injured Ms. Martinez. And so it's regrettable, Judge. There's no doubt about that.
No
And
here,
this incident
James.
happened in a matter of seconds. And that's why we're here 2 years later doing that. And in addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower
$1 million
burden,
of damages.
where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to enter.
They were in the elevator.
And that's what started it.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million damages in civil lawsuit right here. You want to see it, Judge? It's public record.
I would object just because relevance.
So lawsuits and filed in the city court. That's a copy from the courthouse.
All right, unless there are some facts that are listed in the,
It pleads the
Lawsuit.
whole case, Your Honor. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, well, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will,
It does not, Judge.
all right, so,
Just to let you know, there is a civil suit.
all right, then the objection will be sustained. All right, anything else from either side?
No, Your Honor.
No.
All right, I've read your letters that were presented, and it appears that, you know, other than this one incident, you're a great person. But sometimes sentencing, well, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. Is that correct or is that not correct?
You were on the elevator.
Your Honor, the elevator's doors open. They entered into the elevator and they were asked, there were too many in the elevator, and the elevator operator asked people to voluntarily get off.
All right, so there were already people on the elevator. Then you got on the elevator and you were asked to get out?
Let's just walked in at once.
All
And
right,
then
and then you were asked to leave.
they said we need people to get on.
All right, so why didn't you just get off the elevator? That's what I don't understand.
Sure. You didn't decide that.
Yeah.
She didn't decide that. It was a person that she was with, Your Honor, who is a defendant in the case that's in another court.
So my question is though, if there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled. I'm assuming, and correct me if I'm wrong, people were on the elevator, they had not met maybe their 7-person capacity. And then you and your group come on, and because of the number in your group, they've exceeded their 7-person capacity. And then they're saying, you all need to get off the elevator and wait. Why not just get off the elevator? That's what I don't understand. Even if you're with somebody in your party who says, I'm not getting off the elevator, why didn't you just get off and I'll wait for the next elevator? I'll take the stairs. I don't understand.
We had already gotten off 2 floors, so we said like, we've been waiting, but we didn't want to be the ones to get out.
And was alcohol involved, or people just don't want to take
It
the
was after a
stairs?
football game, Judge.
Estate, does anybody want to? I know the complainants are here. Do they want to
No,
say anything to the court?
no.
Okay,
Oh, Your Honor, may I have one moment?
yes. And then after this, we're going to take up Pete Diaz, Emmanuel Castro, Michael Martinez, Larry Berry, and Michael Moore.
Your Honor, I'm going to call case once again.
Okay,
Your Honor, he's not a victim in this case. Why would he come to?
I mean, we'll see what he has to say. I don't know if he's a relevant witness or not, but if he were present at the scene.
You know, I would think that the person involved is the one who's, in this case, is the one that would need to address it. He's had his day in court. He has spoken before the court. I don't see why he needs to speak in this case at sentencing.
All right, you can call your witness.
State calls David Martinez.
All right.
Your Honor.
You're welcome. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Okay, now we're gonna hear what really happened in this elevator.
David Martinez.
All right, state.
Mr. Martinez, from your memory, what occurred on that day?
On that day, we were in line to get into the elevator. The capacity of the elevator, of course, as I mentioned, was 18. But because of the COVID era, there was an elevator attendant there. She said only 8 could be allowed in. We were 3 couples and 2 children, which were a total of 8. As we walked in, we were already in the elevator. They decide to come in behind us. The elevator attendant told them they need to step out. It's full. They had been intoxicated. Her friend.
Objection, speculation.
Overruled.
No, they were
No. Yeah, here's the thing. Where you cannot address the attorneys. Once an objection is, no problem. Once the objection is raised, just stop speaking. I'll make a ruling on the objection. And then I'll let you know if you can continue or not, if you have a question about that. That objection will be overruled.
He came in, stood at the door, prevented the door from closing. Began to.
Objection, Your Honor. I just asked for clarification from the ones. I don't know who he is.
Which he are you speaking about, sir?
Her partner, there was 2 gentlemen, which was the initial one that started arguing with us. And her partner that she was mentioning that walked in, and they were not, we were already in the elevator already when they decided to block the door from closing. Can't recall the individual's name, but it was a younger gentleman that was with her. He proceeded to argue with the elevator attendant about, letting them in or not, that it was BS, that they cannot be let in because there was a lot of room. And she told him they had to leave. He continued to argue with her, and he said that he wanted to talk to her supervisor. And she says if that's the case, she shut off the elevator. And that's when words were back and forth. They continued berating us. She was cussing like a sailor, as well as the other ones. We kept quiet, and they started again.
Sir, there's nothing wrong with that. And it's not illegal. Sir, you keep your opinions to yourself, sir.
Arguing with us. We stayed in there. The kids were already getting terrified with what was going on. They started crying, and they continued with their vulgar language. And I just told them one time, that's it, F you. The gentleman that was with him got upset. He literally from the outside ran into the elevator, knocked us all over and, assaulted all of us in there. I grabbed him and I pushed him out. It was not the individual that she says was in there. It was the other individual that was with him that probably hosted them to the game. And he and I went outside and after that, what?
From there, sir, is that where everything happened?
Correct.
Pass it with this judge.
Any questions?
Mr. Martinez, I'll just start right from leaving the elevator. So by the time that you set foot out of the elevator, you're in the middle of a physical altercation, is
I
that right?
was, yes, while I was on the ground.
Okay. How much were you able to perceive about what was happening around you while you were in the middle of that?
Well, I was
altercation?
on the
If you
ground.
let me finish my question.
All right, it's,
One at a
Right,
time,
talk.
sir.
So my question was, how much were you able to perceive about what was going on around you during the middle of that physical altercation?
And I was not able to see when I was in the ground, what was taking place after that.
Okay, and we can agree that the incident in question, the basis of this criminal case here today is something that happened during the middle of your physical altercation, right?
While I was on the ground, yes, and then afterward, I did get up and partially saw my wife on the ground with a bloody nose. She was
Sherry, that lawyer, the defendant's lawyer, extremely unprofessional, outstandingly unprofessional. Should be sanctions for what he's doing with his shaking his head and throwing his hands up and sighing and all that. However, it's Judge Boyd, so she won't put any weight on his theatrics. Still, so unprofessional.
in the days and I asked her what happened. And I told her that she got hit. She said, yeah, I got hit multiple times. And I said, well, why didn't you defend yourself? She says, I couldn't because I was being held down.
Can you say for certainty whether or not Mrs. Segundo was acting in defense of another whenever she got involved in this incident?
I'm gonna object to relevance.
All right, that'll be overruled. You can answer the question if you know.
I can't say that, but I can answer.
Oh, and I understand, Mr. Martinez, the want for justice on behalf of the injuries for your wife. I just want to make sure that we're also serving justice here for Mrs.
Absolutely.
Segundo today based on her amount of involvement in this incident. And
There was
so-
no, go ahead. I'm sorry.
Go ahead, please. finish.
No, there was only two other parties involved, three parties, and the individual who was with me had already left. But it was only her left with her friend. And there was nobody else around. There was people watching, nobody was getting involved, but they were the only ones actively, physically getting involved.
But, and I know we started this conversation based off what's happening when you're leaving the elevator. Prior to the altercation and leaving the elevator, would you say that in any way Mrs. Segundo was the instigator who was trying to start this situation? I have no further questions.
All right, any other questions?
Nothing from the state judge.
All right, thank you.
This is, sir.
All right, any other witnesses?
No, Your Honor.
All right, the court will hear final argument if there is any.
Your Honor, I think it's clear that Ms. Segundo did not start this incident. That her actions occurred outside the elevator as a result of defending another person. She doesn't deny that she struck Ms. Martinez, that this was a situation where she was struck as well. And we believe that this one incident that wasn't premeditated, it wasn't started or caused by her. It reminds me of a penalty, and another individual comes in their aid, and then another flag comes up for a penalty, and they both get penalties. And in most cases in sports,
That's great, lawyer. That's good law right there that you're putting in front of Judge Boyd.
offsetting. And I think in this case.
Penalties are offsetting.
Looking at the situation.
So if they committed a crime and I committed a crime, nobody committed any crimes, Judge. Because in football, penalties are offsetting. Okay?
And looking at history since that day, that I think it would be fair to give this single mother a chance to continue her life and being a mother and working at her employment. So not to have this crash down on her with her children, with her workplace. We can't.
So there were children in the elevator who witnessed this too. And she wants to work with children and animals. So she can't have a felony on her record because she wants to work with children and animals.
Promise that she will keep her job upon this conviction. We cannot promise that she can be able to parent her children and be the primary caretaker of her children as a result of this conviction. But we can promise that if she is given a chance, she will do everything in her power to remain on probation for 7 years, to do what's right, so not to be considered a felon in a situation that she wished never had happened. There's no ill will here. There is no desire on her part to do anything but to
Love
move
you,
on with her
Linus.
life and pay what's owed, the $2,500, and do what it takes to win your trust. So we're asking, Judge, that deferred adjudication be given to this woman so that she can continue to do her life and do good for her children and her work and her community.
State, any final arguments?
Your Honor, the concern from the state here is, again, the facts of the case. It's that, yes, she wasn't the instigator, but she chose to take it to this level. It was her choice to take this out on the complainant. It was her choice to get involved against the complainant and to not show restraint. It's the issue that this all started over something very trivial, that if just a little bit of patience, this would have all passed over. That moment that she decided to act how she did has affected the complainant from that day until today. And it's going to affect her past this. That's why the state is asking for probation on this case and for you to not grant her deferred adjudication.
All right, so what is the amount of restitution and who is the restitution to?
It's to Rebecca Martinez and
$2,416.29.
Wait, 2,400?
$16.29.
And also in the plea bargain agreement, it says restitution to,
Jeanette Rojas.
yes.
Your Honor, so we haven't gotten any medical or billing from there. We would ask restitution to be determined on that amount.
All right, so with regards to the restitution to Jeanette Riojas, if there's a restitution amount that's submitted to the court and you all have objections to it, we can have a restitution hearing.
Thank you.
And I'll just write in that there's to be a restitution hearing as it relates to Jeanette Riojas. And I'm assuming she's going to want to transfer to Houston?
Yes, Your Honor.
And what,
The way she said
It's
that,
in Harris County.
remember Jeanette? Remember it came in like an octagon square, not square, an octagon shaped box. Jeanette, never mind.
all right, Ms. Segunda, I've listened to all arguments. I want you to know I paid very close attention to the arguments that were presented, to the witnesses, and to all of the documents that the court reviewed. I realize that sometimes when things happen, it's just a Snapchat or somebody's life, right? It doesn't mean that the person is a horrible person. And I'm sure if people could go back and change things, sometimes people are serious when they say, if I could go back and change things, I would. Maybe I never would have went to the game. I would have just let the elevator went. I would have taken the stairs. I understand that. But we can't turn back the hands of time, right? And the problem in this case, and one of the things that I'm looking at is the fact that the complainant has serious injuries. And it has nothing, my consideration on whether they're a judge or not, that's not playing any factor in my decision. If she did not have that occupation, let's just say she worked at the HEB, for example. Then based upon her injuries, she wouldn't be able to work at the HEB. She wouldn't be able to stock. She wouldn't be able to stand and be a cashier. I don't know what they would have her doing at the HEB. You understand? So her injuries are very serious injuries. And I've read the report that was given to me about her injuries, and I've read the PSI report, and I've read the police reports again in this case, because I always like to review things. So I understand that you're very sorry for what happened, but sometimes, yeah, it's great that you're sorry. It's great that you've internalized things, but there is still some punishment associated with it. And I understand that sometimes when people have felony convictions, they say, well, now I can't do this, I can't do that, I can't do this. But then when you look at the complainant, Complainant has some lifelong issues. And that's the report that I was given and that your attorney has read. The injuries that she suffered are not going away. And from the report I read, it sounds like they're never going away. She's always going to have those injuries. And I think you know that when people have broken bones, there's a change in the weather, their bones ache. I have it with my fingers because at one point in time, all my fingers were broken on my left hand. So I know when the weather is changing, it gets a little bit painful, not unbearably painful, but it does. So those are a whole host of things that happens when somebody suffers the injuries that she suffered. I understand, as I said, that you're sympathetic, and I believe that you're sympathetic, and if you could do things over, you would. But I am where I am right now, okay? All right, this is what the court is going to do. Court will find you guilty, sentence you to 7 years in the prison, suspended and probated for 5 years. There's a $500 fine that will be probated. There's a transfer to Houston, Texas.
And that is crazy. That what we just heard is crazy. 7 years in jail because of a fight in an elevator. We have domestic violence cases where they're in there for their 6th or 7th or 8th or 9th attack on the same women or multiple women who get 7 months maybe deferred. She has 7 years in jail hanging over her head. She has to go 5 years without breaking the law. Breaking the law, breaking the law. But that's crazy. Then she also has a civil lawsuit for $1 million hanging over her head.
Harris County, taking consideration County Court Cause number 693701. There's to be restitution of $2,416.29 to Rebecca Martinez. There's to be no contact with Rebecca Martinez or Jeanette Riojas. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 100 hours of community service restitution. That'll be waived once you complete parenting classes. There's to be regular reporting by Zoom or in person, regular UAs, and restitution hearing as it relates to Jeanette Riojas. I don't see this as an anger management situation. I see this as an aberration. I think she doesn't need anger management classes. So is there anyone going to object to me not giving her anger management classes?
The state won't object, Judge.
All right. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful? All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yeah.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So what I've learned in my time on the planet, it's just best when somebody says, oh, you can't do that, and you want to argue about it, pick another day to argue about it. You understand? All right, good luck to you.
Bureau lead.
That right there is pretty unfortunate. I made a mistake. I need to see how bad the mistake was that I made. Because that is the latest video. Hold on, I gotta see how long this is. This is supposed to be the earliest video first. And that is the latest. Hold on, 1 second. I'm press play for a second. Nothing's happening. I'm pressing play, and absolutely nothing is happening. Supposedly, it is playing right now, but it's just not playing right now. I don't know what's going on. I have an idea. Not to worry. I have a better idea. I am the boss of this computer. This computer is not the boss of me. But that is unfortunate. I stitched together all the cases, changed the size, I wonder if I did it backwards. Hold on. That is absolutely unfortunate. So, here's what I'm going to do. What is here? I'm going to show a quick case of something. While I restitch this, it'll only take 4 minutes. But you don't have to sit here for 4 minutes. We can watch this. We need 4 minutes. It's just one of my old live streams. I don't even know what it's about. But it's probably so good. Oh my goodness, so good. And you don't hear anything. Of course you don't hear anything. Of course you don't. So I have it muted. There we go.
You got $100,000 for me?
Thanks, James. Thank you so much.
You got $100,000 for me? Hey, Judge Boone, if you're handing out $100,000, me too.
All right, you're here on a 48-hour affidavit. Nothing's been filed as of yet. I'm just going to say on and your conditions of bond. It looks like you may have possible charges of assault on a law enforcement officer, domestic battery, and then interference with a law enforcement officer.
I wouldn't know how, sir, because they told me I wasn't going to jail, and then they attacked me with the taser and took me down, and I didn't hit a single person. I got that all on camera by the neighbor that had a camera hanging from her tree.
Okay, well, that'll be good.
Come on, pause. Please, someone find that neighbor and send me that clip of him getting tased. Please.
File that today, that's not what it's for.
All right, and my
Anderson,
bond's
what's
been
county
already
attorney's
bonded me out
position on
twice.
bond for Mr. Stropes?
Your Honor, this is an individual who has quite a bit of history here. There's several.
The history's all fake though, sir. It's all people calling me in for no reason because they get pissed
Hang on a
at me.
second, Mr. Stropes. Be quiet so we can go through this.
All right, sorry.
There's several unfiled reports which may become filed at this point. But concerning just this affidavit, we're dealing with misdemeanors. Given the charges themselves, the state's going to ask for a $2,500 cash or commercial surety bond.
Well, I've already paid $1,000 to get out, sir.
James? Dear
All right, that's fine.
James. James. Now that you're a member, I guess I should mention the videos that I have in the members only area are few but traumatizing. Tread with your eyes wide open that they are inappropriate and traumatizing.
The state's going to ask for that. But Judge Dries has already signed the affidavit, and Judge Dries has already set the bond at $5,000. All right? So I'm not going to go over the top of Judge Dries. We're going to set that bond at $5,000 cash or commercial surety with bond conditions that no contact with Stephen Haney, no contact of any kind, no friend-to-friend or face-to-face, friend-to-friend, social media contact. And then also no drugs or alcohol, no illicit drugs or alcohol can be tested randomly. Mr. Anderson, anything else?
No, Your Honor.
That's all I have.
He's not happy. He does not want to leave.
Be right back.
Nope, just kidding.
That's all I have. You're next person.
Circuit Court, Board of Wexford County.
Here's our pro se.
Case of the people of the state of Michigan versus Paul Dean Burns Jr. This is case number 23-13651-FH. The court recognizes here in the courtroom today Mr. Corey Wadings, the Wexford County prosecutor on behalf of the people. And joining me today via Zoom from the Wexford County Jail is Mr. Paul Dean Burns Jr. Mr. Burns, can you see and hear the court, sir?
Yes, Your Honor.
All right, folks, we're here today because typically on Fridays, I've got a lot of final pre-trials, and I don't have them today. So looking forward to next week, I see that we have Mr. Burns scheduled for next Friday for a final pre-trial. That caused me to remember that on our last court date, which date was that, Madam Clerk?
I believe it was September 8th.
September 8th, we had a discussion with Mr. Burns. And at one time, initially, Mr. Burns was represented by Mr. Jeffrey Harrison of the Wexford Missaukee Public Defender Program. There was a request to terminate Mr. Harrison. The court granted that. There was also a request for Mr. Burns to represent himself. And then somewhere in there was a conversation where Mr. Burns mentioned or seemed to accept the idea of having another attorney appointed. And he also then, toward the end of the conversation, said that he wanted to represent himself. Based upon the court having several things on the docket, the court appointed to have another attorney to assist him. Now, in my request to take a look at the file today, I see that Mr. Burns has filed on September 11th a notice of appearance, and is basically requesting to represent himself. Now, last time we were on the record, I talked about the defendant's rights to represent himself, but based upon the back and forth a little bit with accepting a possible appointment, wanting to terminate Mr. Harrison, a lot of the things that he was stating seemed to be disagreements with Mr. Harrison. I did not find that the waiver was completely unequivocal. Plus, the court must, as the case law suggests, must make every reasonable presumption against waiver of such a fundamental right, such as the constitutional right to be represented. So, Mr. Burns, I'm just merely covering today for the docket. As we get closer to this case being on our final pre-trial schedule and then for trial, I needed to cover certain things here to make sure that you and I are on the same page. So, one moment. Pursuant to Michigan Court Rule 6.005 and particular case law, including People of the State of Michigan versus Anderson, People of the State of Michigan versus Denany, D-E-N-N-A-N-Y, and People of the State of Michigan versus Arthur, There are certain rules and, even more importantly, some thresholds the court must cover before the court can accept the waiver of the constitutional right to representation. The first thing the court needs to do is make sure, and now that I've got nothing on our docket today, I've got plenty of time to deal with this, make sure the defendant's well informed of what the charges are. And I don't know, Mr. Burns, if we did all of this last time, because there was quite a bit of colloquy about Mr. Harrison. Number one, count one. You are charged in a felony information with count one of possession of a controlled substance methamphetamine, which is a felony punishable by up to 10 years and or $15,000. Now, there's a request to treat you as a second or subsequent drug offender. That could increase that maximum punishment from 10 years to 20 years and from $15,000 to $30,000. There also would be an increase of the sentencing guidelines. In the alternative, there's a request to treat you as a fourth habitual felony offender, which could increase that maximum punishment from 10 years up to life.
Yikes.
Count two is operating while intoxicated or under the influence of a controlled substance. That is a misdemeanor punishable by up to 93 days and or $100 minimum to $500 in fines plus costs and or 360 hours of community service plus rehabilitative programming, vehicle immobilization, cost of prosecution, reimbursement for government emergency responses, and expenses for prosecuting the defendant. Count three is operating a vehicle with no license or multiple licenses. That is a 90-day misdemeanor and or punishable by up to 90 days and or up to $100 plus costs. Now, these last two offenses also could result in the Secretary of State taking some sanctions or applying some sanctions such as points and otherwise to your license. That's step one. Step two underneath this court rule is that I must also discuss with the defendant the risks involved with self-representation. There are several risks, but some of those are easy to determine. Number one, hold on, before I move into that, Mr. Burns, have you received a copy of the felony information?
Yes.
Do you understand your rights? Do you understand those charges?
Yeah, I understand.
Yes, and you understand the maximum punishments?
Yeah.
Life.
I just have, okay.
Yes.
For me to be able to grant you your waiver, which the law requires me to go, the law requires me to favor somewhat against it, I have to go through these special questions. And you and I did not fully get that opportunity last time. But now I'm doing it today for the record, so therefore I can grant your request to represent yourself. If negotiations continue, any negotiations the prosecutor has would have to be with you. Do you understand?
Yes.
Now, that doesn't mean you have a right to have a negotiation, for instance, a reduced charge or otherwise, but any negotiations would be with you.
It would take a lot for me to do traffic court again. I used to do traffic court. I used to have lots of clips from traffic court because people do the craziest things in traffic court. But there is so much boring in between that. So you would have to actually do something pretty spectacular in traffic court for me to think about even trying to look for traffic court again. Like attack a judge in an elevator maybe, then I'll do traffic court. Monica, thanks for the cheers. Thank you, thank you, thank you.
The only caution that I have here for you on that is certain things that if you were to make any.
This is long, and I want to get to Blandino. So I'm going to fast forward it to the good bits. Okay? Yeah.
With whom to consult.
Your Honor,
So, yes, sir?
I was under the impression that I couldn't file anything. You sent it back to me. I had no reason to believe that I could file a motion after you ordered me to take appointed counsel, and appointed counsel never came up here to see me. So in either hand, I could not proceed forward. I went to the Court of Appeals. If we're gonna get it on the record, let's get it straight. I don't have the impression that I'm free to file motions, and I don't want to file them and have them sent back to me if the clerk's not gonna file them.
If you don't file them
I
according,
asked you what day the motion day was, and I noticed all the motions. I would notice each one 7 days after the date of the nearest motion day. I know how to file a motion, and I know how to notice it. I wanted to at least be received by the clerk so that in the event that we were going to go forward, I was going to, at some point, we got pretrial motions that haven't been done, and was certainly not done in the district court. I've asked for a remand, or at least let's get the Ginter hearing going so that we can go back and start there. I feel that's the only way that we're going to be able to get the prejudice fixed that's already involved in the case.
all right, so let's go ahead and break down the myriad of things you just mentioned.
Okay.
Number one, the court appointed an attorney to assist you. 3 days later, you informed the court that you didn't want that attorney by filing your own appearance to appear without counsel. Is that correct?
I just got to say real quick, the judge is being careful right now because he reached the end of his rope during that whole talk that he did. He reached the end of his rope. He's done right now. And instead of just saying, I'm done, because you know how judges are when they're done, they're done. He's going forward. He's trying to be careful, but he's done. And this guy makes it worse.
Never even met an attorney. I don't know what you mean. The
Mr. Burns.
Yes.
Mr. Burns. But we have already addressed that because you told me you do not want counsel appointed. Is that correct?
Is this Taekwondo here or what? I've stated under the circumstances how that happened.
No.
No.
Do you?
I wanted to. If there was an attorney that I was able to consult with, I would have consulted with him. There has been no attorney for me to consult with other than Harrison, and Harrison wasn't consulting. He was doing whatever he was doing with the sniffles or whatever. No, I didn't have an attorney to consult.
Mr. Burns, stop talking. Pay attention. The question's very simple. And I've asked it.
The answer's very simple.
Stop
no, I didn't
talking, Mr. Burns. If you interrupt me one more time,
I will hold
you in contempt.
I will pull this car over.
If you were to ever get sentenced on this case, you will not get credit in that sentence for the time you're serving for contempt.
Yikes.
Do not talk when I'm talking. Now, the question I have for you is, do you want an attorney to assist you? Yes or no?
To assist me in what fashion?
Represent you in a criminal case in a criminal courtroom here in Wexford County.
As a lead counsel.
Do you want counsel at all? You've said yes and no back and forth.
I said if you have an assistant that can assist me in complying with the court rules, then because of what down at the jail here, I don't have all the access to the materials. If that's the case, fine.
Okay, that's different than what you've said. So
how is it that I've said?
It is because you've also told me you're somehow appealing in the appellate court for me appointing an attorney, but now you just told me you want me to appoint an attorney to consult with. Which one is it that you want? Do you want an attorney to do not interrupt me? I hold you in contempt. I'm adding 20 days to your sentence. I've warned
Daddy
you twice.
pulled the car over.
That means if you ever get sentenced on this case, you do not get credit for these next 20 days. Done. Now, pay attention very, very clearly. It's a very, very simple question. Do you want an attorney to assist you or to consult with? Yes or no?
Stand on the record.
But the record's unclear. It's an unequivocal statement, which means I can't let you represent yourself if you make an equivocal statement. I need you to answer the question. Do you want an attorney appointed to consult with or work with in some degree? You are directed to answer.
Allow me a minute.
Okay, take your time.
The judge is trying to cool down. Cool down.
Who are we talking about?
I don't know, but it won't be Mr. Harrison. You don't get to have your pick and choice. I will appoint some. I don't know. I don't know who it will be. I don't make that job. The law does not allow this court to appoint a particular individual. They do not work for the court. I only appoint, and then the system, the Indigent Defense Commission appoints an attorney based upon that attorney's availability. So if you say yes, you want an attorney appointed to assist you or to consult with, then I will sign a piece of paper that once again says they are to appoint an attorney. It won't be Mr. Harrison. Then that attorney will come and speak with you. And then you guys can begin to talk about a case. That attorney can consult with you in little ways or big ways. Meaning they can help you, they can help represent you and give you guidance, or they can represent you in the court as if they were the active attorney. But then the public defender, the public defender system will appoint that attorney.
Now I
So all I need to know is,
Yes.
if you want somebody. Okay, that's all I needed to know.
It's understood. The way you explained it there, I understood.
Okay, all right. The court will once again appoint an attorney, consult with.
Oh boy.
And then we will have our final pretrial conference next Friday. Either you or that attorney can file motions. The court will still entertain them.
That was the good
even if
part.
we are past the due date.
That's the good part. There's no more yelling and screaming. That was it. That was it. That was it. Time. It's time for us to stop playing around and us to get to Kim Blandino. And you're going to wonder why we waited so long once it starts. Because he is just excellent content.
332496 on page 3. Mr. Blandino, sir, you need to have a seat.
I'm requesting to appear amicus curiae on behalf of.
Sir, no, you cannot.
Mr. Aparicio, and if I'm denied, I'd like to have it denied on the record.
All right.
I'm not being scared out. I want to,
Just to be clear, Mr. Sheets, you are counsel of record in this case, right?
I am.
Okay. You're not requesting any assistance from Mr. Blandino, right? Okay. Right, so this is on for a motion to reconsider the denial of the motion to disqualify Judge Smith. Mr. Sheets, anything that you want to add to your motion?
Just briefly, the distinction that I'm making is I'm not only asking Your Honor to recuse him from future proceedings, but to recuse him from the prior decisions that he had made for that inherent bias.
I don't believe I have the authority to do that, Mr. Sheets. I think the remedy for that is an appeal. I mean, I can remove a judge from a case, I can't change their prior decisions.
Well, I think the concern is that if we're removing you based on alleged bias that came during the course of that decision, the determination of bias is imperative to ensure that the client receives due process from the very beginning.
I understand what you're saying, but I don't think that's within the limited scope of what I do when I consider a motion to disqualify.
I guess that's my concern, is I do think you have the ability to disqualify, and I don't think the statute defines disqualification from all future proceedings, especially when the inherent nature of the disqualification would be bias. And I think the disqualification in and of itself would allow the litigation of the issues underlying bias. That's why it's a system that was put in place to protect from bias inherent in the proceedings. And I think that when if we just say it has to be from the date that the bias is known.
If you're lost, it just gets worse when Kim Blandino actually speaks. This is just a lawyer. Don't worry, it gets worse.
Notice forward and nothing else. I think that's probably not necessarily addressing the legislative intent of allowing somebody the opportunity to have a tribunal that is free from that inherent bias with regards to all decisions. Now, I mean, obviously, ultimately, if Your Honor denies today, my intention is to go back and ask the court to reconsider based on the bias. The state will then argue that the denial here is tantamount to the finding of non-bias, and then we'll have an issue there ultimately.
Well, no, I didn't make any finding at all because I don't need to at this point because Judge Smith is not here anymore. So, I mean, I don't. All right, Mr. Markowski, anything that you want to add?
No, Your Honor.
Okay, so the motion for reconsideration is denied, and do you need a date in, it looks like you have a calendar call on the 31st?
Yes.
Okay. Thank you.
Driving on a $85 warrant. Let me ask you, sir, how much does he owe?
He has to, hasn't, but yet, so at this point, he just.
Mr. Blandino. That's you, right?
Yes, sir, you're addressing me?
I am addressing you. Let me get a picture of you here.
Okay.
Now, you came into my private office about something. Because of that, you can't be in this courtroom right now. So you have to go.
No, I don't think that's true.
All right, well, I'm ordering you to leave this courtroom right now.
Okay.
And if you don't get out within
I'm
10
gonna
seconds.
check with Woolsey.
Okay, 10 seconds, you're gonna be held in contempt.
You're out of order.
All right. Have a good morning. Don't stalk people.
7, counsel, you're here for the record.
Mike Dickerson on behalf of the state. Kim Blandino appearing pro se for Kim Blandino with standby counsel Ben. Good morning, Your Honor. Ben David, 933.
You guys can't hear it?
Elbow. I have some administrative and procedural matters before we even get to anything.
Because this sounds
This is status check counsel.
lower than the last one.
Has not yet been evaluated, and so the court's going to need to continue this out for him to be evaluated. As a result, we're going to need to vacate the current trial date, let's say.
Mr. Blandino, have you been evaluated?
By who? My friends and family evaluate me as perfectly sound and knowing quite a bit about the law.
Okay, so you haven't been evaluated by a doctor yet?
I've been to this whole clinic where they're a medical doctor, but not. Are you meaning psychologists or psychiatrists?
Counsel?
I just want to be
I
specific.
just
For the record.
Yeah, so we would just need him.
turn the clips up and I'm exporting that. It'll take like 4 minutes. So just limp along for a while.
As a result, it's going to necessitate us vacating that trial date.
there any objection to vacating the trial date and setting a new date?
I have some administrative and procedural matters. I don't want the court to just gloss over those. I have a right to
We're
make a
gonna
record.
get to those in a minute,
Okay.
okay? But first I wanna deal with this issue. This is why it's on calendar today,
Yes,
so let's
I have an
deal with it.
objection to this entire competency proceedings. This is
Okay,
merely
so we're gonna,
vindictive on part of the DA's office.
all right, everybody take a deep breath. All right, now, do you have any objection to vacating the trial dates and continuing them?
If you want to continue to another date, you're not the normal judge, I understand, on this case anyway, so I don't have an objection to that continuance. I just have objection generally to the going through competency proceedings. I don't
Standby
believe the
counsel,
right.
do you have any objection to vacating the trial date and setting a new date?
Well, I do not. I think, obviously, it's been ordered, so, but, court's indulgence.
I just want for the record to be known clearly, Judge, that I haven't waived my speedy trial right. I was willing to waive the time that the DA objected to. However, they were the ones that asked for the stay in the other court, Michelle Levitt's court, to go through these competency proceedings, which is merely vindictive on the DA's part. So therefore, I don't have any general objection to continuing it. I mean, I think that's fine. You're not, Linda Bell was supposed to be here on this date. I understand you're subbing in. So one of the administrative and procedural matters that I wanted to address was the fact if there's a written request pursuant to District Court Rule 18 that requires, or that allows you to sit in for Judge Bell, because this is a court rule that's required to be complied with. Do you have such a written request from the judge that he's sitting in on this matter?
Mr. Blandino, I was assigned to substitute in today for the chief judge at her specific request.
Was it a written request? The rule requires a written request. I've got copies of it if you'd like to see.
All right. So you object to me presiding over this case today? Is that what I'm hearing?
Well, I have a general thing that I was not able to present. This court needs to take judicial notice. There's a vexatious litigant order against me. Now, while that's on appeal, only the chief judge or the chief judge's designee can allow me to file any written motions. That's why you haven't seen any opposition to the competency proceedings, except for, this is one of the administrative matters that I wanted to bring up. I sent, Your Honor, an email copied to the district attorney, both Dickerson, Marlin, and to Judge Bell, and to Judge Levitt. And so I said that, hey, look, a number of different issues that I've got no other way to do this. It wasn't ex parte communication. Apparently your JDA indicated that that is ex parte, but if I'm serving the other party with a copy, I don't see how it could possibly be. But even so, Rule 2.9, which I adequately copied and sent by way of email, shows clearly that if there is ex parte communication, either inadvertent or otherwise, as long as the opposition has an opportunity to respond to said communication, you're perfectly well within the Rule 2.9. Now, since I can't file any written motions without the chief judge designees, because Judge Bell actually has an unadjudicated motion to disqualify against her, but my position is, and always has been, that this case needs to be assigned to a judge outside of this district. I'm gonna have to call multiple judges in this case. I've been accused of impersonating a public officer, so I'll have to call as witnesses, subpoena with evidence and testimony, and written documentation, members of the Nevada Commission on Judicial Discipline. I've been accused of extorting a temporary judge, and in that regard, it's absolutely imperative to show that I've been doing this for years, so I'm gonna have to call Judges Herndon, Judges Baer, ex-Judge Maupin, ex-Justice Maupin now, all these different things to show that I have in good faith been investigating judges for corruption and for misconduct for many years now. And I didn't even realize that for many decades, I've been brought to the point to which I've been brought here now. And that is having all this information, all this legal knowledge, and knowing procedures. I've been put to this position to make these claims. And so the DA wants to do a drive-by conviction of felony. And Kim's counsel, which is me, is not going to allow that. Kim has to represent his client, which is me, zealously and vigorously, and will do so to the best of his ability. I'm doing this full time. I'm doing basically nothing but eating, sleeping, and doing legal work. Aside from the normal chores that you have to do, make your bed and things, but that's all I'm doing. And so, if they want to do some kind of drive-by trial and vindictively put me through these competency proceedings, I am going to object to that. And I'm going to object generally to any district court judge hearing this. I've got a prima facie case. Manning versus State was just decided just recently, is coming back down on vindictive prosecution. When a prima facie case is made for vindictive prosecution, there has to be an evidentiary hearing for that. Now, this latest scheme by the district attorney to put me through competency proceedings based on my filings before the Nevada Supreme Court clearly show additional vindictiveness based on my religious beliefs and my right to exercise my religious beliefs and my right to seek redress from an appellate court. They're saying, okay, Kim, we'll turn the screws to you just a little bit harder now and put you through competency proceedings. And maybe, just maybe, we can find some psychologist that's off his meds or something and will find you incompetent and relieve us of the necessary prosecution, and then they can lock you up in Lakes Crossing for some time. Well, Kim cannot allow that to happen as good counsel that he is. If the defendant could speak for just a minute, as I just did. But I have a general objection to that. Because of the vindictiveness of prosecution, they really should recuse themselves. They know it's vindictive. I just got discovery yesterday after they, in open court, said on their honor they would have it in the Justice Court. Now all of this information, it appears, they had as of May 30th of this year, and now they're just delivering it. They violated the 5-day promise within the preliminary hearing. Now granted, they went to a grand jury indictment. That doesn't negate the vindictiveness of this, though.
Counsel, any objection to me hearing this matter? See.
No, Your Honor.
All right, what I'm gonna do is vacate the trial date, set it for status check in competency court. Thank you, Mr. Blandino.
November 1st, 10 a.m. I'm sorry?
November 1st at 10 a.m.
November 1st, and then which court is that going to be?
Right here.
He's a legend in his own mind. Kim Blandino, that's
No, I
me.
don't know.
And Your Honor, we'll issue a written order on that. That's just want to confirm that all proceedings are being suspended pursuant to NRS 178.405.
Correct, counsel.
Thank you.
There was one other administrative matter, and this is important to get on the record. I had issued an objection to Mr. Ben Bateman being a standby counsel, and that was in Levitt's courtroom because I hadn't interviewed him. Didn't know if there was any conflict. I want to, for the record, say that I approve of Mr. Bateman as my standby counsel. I withdraw the objection that was entered the last time in Judge.
Noted. Thank you, Mr. Bateman. Have a wonderful day. Next.
Thanks, Judge.
Kim Blandino, 22 CR 041030. Oh, I seen him.
Kim Blandino, 3 Pro Say 4 Kim Blandino.
All right, I seen that Mr. Schwartzer did a reply on this. Are you covering this?
Mr. Dickerson filed.
Oh, Mr.
response to our-
Dickerson.
And yes, I'll be covering today.
Okay.
Absolutely.
All right. Okay. Mr. Blandino, I did receive the motion. I did read the motion. Is there anything you want to add before I make a ruling?
Well, I'd like to notice that it was 3:40 yesterday that the state filed the counter motion to strike for a fugitive document. I got a copy of it here, but didn't have time to research this or anything. But I kind of object to this being filed at such a late moment. What I want to make sure the court understands is there were 2 identical passports. They're both originals. You have ambassadorial status like I do. You have a backup so you don't have to wait. In case you lose one, it's a spare. It's like a spare tire for a car. Common practice. And so the state denied the charge on the one right away in this case. If you look at the record, I asked the court to take judicial notice of that. The other case, they dismissed very early on in the case statutorily, so it's the dismissal without prejudice. But what's happened is I've been convicted, sentenced, the appeal was failed, remanded, did the community service, it's all done. All I'm asking for is my passports back. And that's at the vault. I checked with the vault, they have them, they're ready to get them over, but they gotta get a release. And release can only be done by you. I attached the district court. Mr. Gersten tried to get it done in Michelle Levitt's court, in the district court, and she said, no, I can't do it because they were confiscated in the amendment number here that goes to this court. And so that's simply what I'm trying to do, is just get my property back.
Okay, so, and then state, I'll give you an opportunity to respond.
So Your Honor, first, I'll just note, he mentioned that the response was filed yesterday at 3:43. That is correct.
Okay, this is March of this year, right? He wants his passports back. Just keep that in mind.
His motion was filed March 13th, so we were well within our 10 days to respond. On Mr. Dickerson's response, I will argue that this is a fugitive document. He's represented by counsel. This went to the Supreme Court. It came back. So the court should not consider this his motion, seeing as it's fugitive, and I will submit on Mr. Dickerson's response.
Can I reply?
Sure.
Well, I would have had Mr. Gersten here. He's in Europe until Friday. I think the court knows that because he's assigned to this court, I believe, on a office of appointed counsel type of rotation. So it was unable to get him there, couldn't get him by Zoom. He never returned my call before he left. So in the interest of judicial economy, which this court has already done in the prior case in this court just now, I would like to ask that rather than have to come back and do everything, I mean, the fact that it's fugitive, they're alleging it's fugitive, that was with Judge Cicento. Everything I know about case law and everything, that's not binding on this court before this judge who defeated Mr. Cicento in a valid election. And so I'm not disruptive. I haven't been disruptive. He based that on, and I think wrongly, on my behavior, alleged behavior in the district court case.
So I just looked up disruptive in the dictionary. Guess whose picture is right there? Just guess. You're not disruptive. Okay, I don't talk a lot during my streams either.
Government is proper anyway. And so it's pretty straightforward. My command by my Creator is to love God with all my strength, my heart, and love my neighbors myself. That's taking room. Those passports are taking room. They got 3 different buildings for that vault because of all the property that's confiscated. And if they just, if the state wants to just keep those things, they're going to take, another 3-4 years before they can actually destroy it. And that makes no sense whatsoever. Those things were created in 1993. And I've had possession of them. The state had possession of them when I was convicted of a violation of custody rights in the 90s.
Exactly.
And they had possession of them.
Exactly.
And they gave them back to me. So this has been alternately in possession by the 8th Attorney General, the Department of Prisons. It was the Department of Prisons back then, now it's the Department of Corrections. And it's been held by Boulder City thing. And I've got other documents before that passport. So what I've asked the court, I've got to get this to the Department of State. There's a new regime there in Washington, and I want to get approval by the Department of State for those passports. So if you only even just give me the one passport on the case that was denied by the district attorney early on in the case, then I'll just come back here with Gersten or whatever, however you want to do it, and we'll go for get the other passport. But they said they can release the one separate from the other.
So this is what the court's going to do. I understand that this is a hijack motion, which needs to be filed by your attorney, Mr. Gersten, but Mr. Gersten has filed these types of motions, so I don't think it's an issue of the problem with the hijack motion is you really can't be both. You can't be pro per and represented by counsel. But in the documents that Mr. Blandino provided, it shows Mr. Gersten filing a very similar motion ordered for release of his property for the desktop computers. So I don't think that if Mr. Gersten was present, I don't think he would be objecting to filing motions to get the passport. But what the court didn't see, you said it was in Metro's vault? was Metro served with this motion? Because
Yes.
Metro has to have an
Oh,
opportunity
absolutely.
to
I delivered
come.
it personally to Stacy at the.
Because I did not
Command.
see that. That's what I didn't see.
Oh, no, the proof of service, certificate of service, it shows that.
In your motion? Because I don't see that.
Yeah, I attached a certificate of service showing email, and that's why I put the transcript in there, because Judge DeSanto said, served the LVMPD with that. So here it is, it's page,
Yeah, what page? Because I see, I'm just looking at the end of the emails. I see the Clark County DA, Clark County Courts. I see BRB, LV. I
yeah,
don't.
page 4, look, delivering a copy to LVMPD personally delivered, and the address, 621 North 9th Street.
Page 4.
That's the area command that has to give the.
Oh,
approval
okay,
to
I'm
release
sorry.
the
I went
call.
too far back. I went to the last page.
Yeah, that's where I served it. And I've already got my computers back.
So
in the
this is
case.
what I'm gonna do.
Yeah.
This is what I'm gonna do. I am going to, because let me just make a clear record. Mr. Jerson is in Europe. Okay. So, and the fact that he did fill out this motion for Mr. Blandino's laptops, computers. I don't see Mr. Jerson not filling out this motion or filing this motion for him to receive his passports. So at this time, I'm gonna allow the motion to go forward. I understand the state's opposition that it's a hijacking motion, but there makes no sense for Mr. Jerson to come in 2 weeks from now, file the exact same motion, and now we're back on calendar on the exact same thing, which doesn't really change the merits. So on the actual motion, I do see that it was served to Metro. So what this court's going to do is I'm going to order him. I don't see Metro here unless the state has any representations of them objecting or anything like that. What I'm going to do is I am going to, and I do not believe that this filing is made to vex, harass, or delay. He's asking for his passports. So what I'm going to do is I'm going to order the return of his passports. However, I will reserve, if Metro does get that order and they say, oh no, we have a problem, I will allow Metro to file a response. Because I will give them that opportunity just because this wasn't filed by Mr. Jerson. But right now, I don't see any reason. You've already been sentenced. You've already been convicted. This has already came back on appeal. I don't see a reason why passports are being held.
And I've done the community service, and there is no habeas pending.
So at this point, I'm going to order his passports to be returned.
Judge, may I ask that I can get a transcript of this?
I think you have to.
You have to file, you have to do an
Well,
oral.
Yeah.
Thurston
So
said that.
just have the minutes reflect.
I will.
Okay.
Would you like me to prepare
Yes,
the
you
order,
gotta
Judge?
wait till tomorrow.
Yeah, but it doesn't, he wants this one, he has to wait till tomorrow.
Judge, would you like me to prepare the order?
Yes, prepare it and send it to the court, and we'll
No.
review it.
I'm not familiar with the Justice Court on the electronic. Can I electronically send it? Or do you need hand delivered back here?
Should be able to file it.
File it the same way you filed this motion. You filed this
Well,
motion.
I'm not gonna be able to file a motion without an order without your signature.
No, you can get it to us, and then I will review it and make any changes that
Okay.
are necessary if I find anything, and then I usually will sign it and get it back.
So I
to
can
the
send it
court.
electronically then? Okay.
Yes.
Is that on the website, the email?
How did you file this motion?
I went to the clerk's counter right there, and they did it from there.
Submit that order. It should be-
Submit it to the clerks. You
Yeah.
can submit it through the clerk, the
Okay.
clerk's counter.
All right. Thank you very much, Judge. Appreciate it. Congratulations on the election.
Thank you.
All right. State versus Kim Blandino, 22 CR 041030.
Good morning, Judge. Kim
All right.
Blandino.
State versus.
Standby counsel, well, reported standby counsel, I want to substitute attorneys on this matter. State's filed an opposition. I didn't have time to file a reply.
All right, Ms. Crum, I don't think I saw the opposition.
Right.
It's on Odyssey, Your Honor, but it is very brief.
Okay.
I can
If
just,
you'd like to take a look at it.
oh, that's okay, thank you. I can actually, Your Honor, as the whole of my argument, just read it. It's just one paragraph,
Sure.
if you don't mind.
Sure.
And our position in the defendant's motion to substitute counsel would be that to the extent that the defendant is seeking to represent himself in this case, the state of Nevada opposes such request based upon the law of the case. Defendant's right to self-representation has been revoked in this case and so affirmed by the Nevada Court of Appeals. Moreover, as it relates to appointing any other attorney to represent defendant in this case, there is no indication in the motion that a new appointment is necessary or that there even exists a basis for such request. And with that, I'll submit, Your Honor.
Okay.
Well, I'd like to reply.
All right. So let me make sure I understand this. Mr. Gersten.
Yes, Your Honor.
If you could get me up to speed as to your role in this case.
Very simply, Your Honor. It goes back a bit. Mr. Blandino has had several cases in the district court, the appellate court, and here. I've been appointed in all of those cases based on way back in the district court with Judge Levitt. There was a jury trial. Judge Levitt claimed that Mr. Blandino you want to do this or me? Was disruptive in front of the jury. As a result, she revoked his status to represent himself. Thus, I got appointed. At a later time, I tried to get off of every case and was denied all along the way. It was Judge Sacento in this case where he denied that based on Judge Levitt's ruling that he was, difficult. Disruptive. Sorry, he's going to yell at me for using the word difficult. As a result, I've been representing him. Recently, in this particular case, he's been trying to get his property back. The last hearing we had, Judge Bradford allowed him to appear pro se and do whatever it was that he was doing. I think he was getting a motion signed, an order signed to get his property back. That has not happened. From my understanding, Metro is ignoring the lawful order from this court to return his property. As a result, Mr. Blandino feels he's going to have to file writs, et cetera, et cetera. So what he's trying to do right now is represent himself and not have to rely on my representations. And like I said, the last hearing, Judge Bradford allowed it. I don't know what her ongoing thoughts are going to be.
All right, so hold on, Mr. Blandino. So what is the status of all of his other cases that you represent him on, Mr. Gersten?
The district court case is closed. The appellate court case is closed. My understanding is this is would you stop? This is the only case that is open strictly for this return of property.
How many times a night does T say that to her husband? How many times a night does Mel say that to her husband? Would you stop? Monica, how many times a night do you say that to your husband?
There is a new case, a case that has been filed in the district court where he has filed a writ of habeas corpus. That is currently pending, and I believe tomorrow he has a motion on to represent himself in that case. Did I get that right?
Well, actually, point of fact, I am representing myself currently. I'm asking to have you appointed standby counsel. The status of I've got girls' badge and I'm Rachel 5'8". Motion to overshield. Does that make sense? Can I speak?
All right. So here's kind of how I see this. I have the community service requirement taken care of, and any outstanding, and it looks like all outstanding requirements are completed on this case.
It is, Your
So,
Honor. The requirements are done. And at one point, Judge Sicento was offering to close the case. However, Mr. Blandino's property is still at the vault. He wanted it back. We made a motion in the district court. They granted it partially. He then came down here and made the motion here. Judge Bradford gave him an order to take to the vault to give the property back. Metro refuses to give back the property.
okay,
So he's here, I believe, what he's going to seek is the ability to represent himself and then pursue this idea that Metro will not give him back his property.
okay, so so before I hear from Mr. Blandino, here is how I see everything. All the requirements are completed, and I'm inclined to close out this case right now. There's no forfeiture requirement, so anything that Mr. Blandino might be entitled to receive back, Metro would then see that this case is closed, and they would return that property. However, if it's contraband or they don't believe he's allowed to have it, then that's an issue between Mr. Blandino and Metro's vault. But as far as the court is concerned, all the requirements have been satisfied. So go ahead, Mr. Blandino.
Judge, this goes to the inherent authority of the court. And the fact of the matter was, there were two original passports, identical. They're originals because my original signatures are on them. Judge Sicento said, Mr. Gersten orally asked for it. He said, well, go ahead and file a motion for it. This is before he got voted out of office. And so he said, go ahead and file a motion, but make sure you let Metro know. So, in fact, while Mr. Gersten was in Europe, that's when this hearing was set for, Judge Bradford acknowledged that it was like what she called a hijack or fugitive motion. But she said in the interest of judicial economy, she would grant the order. But she wanted to have LVMPD to weigh in. She waited to issue this order the 10 days for LVMPD to respond. They were personally served with a motion for the return of property, and they refused to answer in any way, shape, or form. When I went down to the vault with a certified copy, I presented it to Rachel, badge number 5887 of LVMPD. And she said that you're going to have to talk to Internal Affairs about it. I called all Internal Affairs. I called counsel for LVMPD. I talked to the investigative specialist, Stacy Cutesy, over at the downtown area command. They've got no basis to hold this. They're saying, we believe they're fake. Those are the very charges that the VA denied on the one passport, and then it got dismissed voluntarily at their motion later on in the case for the other one. They've got no basis to hold that unless they're holding information from me as to why they can do this. This court, like any other court, has the inherent authority to order Metro to turn those in. And if the vault doesn't want to turn them over to me, if they have some objections, then I can do the motion for order to show causes why they should be not found in criminal contempt and civil contempt until they turn theirs over. And then, if they still refuse, ask that the vault bring those originals down here so that the court itself can turn those over to me. And then I can seek other civil remedies in the federal court under the Civil Rights Act. Because I told them, I said, you guys, you get these justice of the peace. Bench warrants are issued. You guys enforce those all the time. So you're going to pick and choose which orders from the court you want to obey and which ones you don't want to obey? Not only that, this Rachel was right there in front of me. The passports are just some feet away from her. Because I had called, they verified they were there. As Mr. Gersten said, I've got my other property on 2 other trips down there, computers and hard drives in the district court case. He tried to package this all up for Levitt to get the order from the district court on the passports. She said, no, you're going to have to go down to the justice court because it was under that case and that event number that the passports were indeed taken. So I'm not asking, I mean, the case already is closed. You can double close it, I guess. However, there's still remaining business to be done on this case. and that is the return of the passports. I should not be required to file a separate federal suit in order to get that property back. Those are passports, they're foreign passports.
Sir, I am always chipper. Always.
I need to get those to the Department of State and get those cleared. Moreover, because I did relinquish not renounce my citizenship, I relinquished my U.S. citizenship, I need to get clearance so that they don't, Tom Holman and the rest of the crew don't deport me from this country, which is possible. Or they could deport me to Montana, where I was born. But be that as it may, I'm following the process here, and I think you as a judge should be indignant to the fact that this order is just being ignored like it's toilet. They going to get a certified copy to present to them, so they couldn't in any way. And I said, you're not doubting that as forgery, because you can charge me and cuff me right now. If you think this is a forgery, and then you can...
All right, Mr. Blandino.
Right down to
Your Honor, if I may be heard briefly,
Go ahead,
I have
Mr.
maybe a proposed solution to this matter. I don't think it would be appropriate to close the matter at this moment because of this ongoing issue. I have had this issue in other cases. I wouldn't say remedy, but the structure of it. What occurred was that the defendant in those two cases, so the two defendants, they filed motions to return the property. I understand Judge Bradford issued an order, but it wasn't accompanied by a motion. I believe a different way we could do it is for the defendant to file a motion to have his property returned. He needs to serve that motion not only on the district attorney's office, but also on Metro's counsel.
I've already done that.
I would ask to not be interrupted at this point. If he wishes to file a motion, Metro's counsel will come down and state their representations. I cannot represent Metro and what they're doing. So I would ask that a briefing schedule be set for that he file a motion, we will file our opposition, or Metro can file their opposition, and that way Metro's counsel can be on notice and come down here. As far as I can see in the records, Metro has not appeared on this case, which I believe they are entitled to because they're the ones who are in custody of the passports. So I would ask to set it for a briefing schedule, and then the motion could be heard. As far as why we're here today, on the motion for substitution of counsel, it would remain the state's position that because the case has not been closed, as the defendant himself stated, there are outstanding matters in this case, and multiple judges, including a panel of judges in the Nevada Court of Appeals, has found that he is not suitable to represent himself. The state would maintain its request that he remain represented.
Every single person here feels that he should represent himself. That's all we want.
By counsel due to his inability to represent himself. And with that, I'll submit, Your Honor. Thank you.
All right.
May I rebut?
Go ahead, Mr. Blandino.
Specifically, Judge Bradford addressed that. In fact, she couldn't find the page initially. I personally served, so there would not be any doubt that I personally served LVMPD for the motion. So now, somehow, even though the state is saying they can't represent LVMPD, they're making representations as though they are, in fact, an advocate for LVMPD, and I object to that. They are impersonating counsel for LVMPD.
All right, so here's what I'm going to... All right, so Mr. Blandino, here's what we're going to do. Although I was inclined to close the case today, based off of the state's representations, I will go ahead and set a briefing schedule for the motion, for a renewed motion to return property. I will order that motion be served on the Clark County District Attorney's Office as well as LVMPD. And then LVMPD will obviously have a chance to respond. I'm not going to order a reply in this case. I don't think it's necessary. And we'll go ahead and set a return date. So, Mr. Blandino, I'll give you 2 weeks to go ahead and file that motion.
So it is granted as a substitution of counsel?
No, I'm getting there, Mr. Blandino.
Yeah.
I'm getting there.
Okay.
So I'll give 2 weeks to file the motion. Ms. Crum will give the state 2 weeks from that date to respond. As to the matter of why we're here today, Ms. Crum Do you have the case that you keep citing to, the Nevada Court of Appeals case?
I don't, Your Honor. I apologize. This was not a motion I filed. I can get it. But even defense counsel noted that the trial court and the Court of Appeals found that he was not able to represent himself. And I would argue, based on what's occurred in this courtroom today, he's not out to represent
Well,
himself.
I guess here's where I struggle with this, because Judge Bradford gave him at least one opportunity.
I believe Mr. Gerson was out of the country, is that correct?
Yes.
So he was not here to represent him because he was out of the country, and I believe she may have given him a limited opportunity to appear without counsel on one specific date, but not that he doesn't need counsel.
Okay.
And Judge Sacento has already ruled on the motion to substitute counsel and has denied it. So this courtroom
That was
itself,
before trial.
this courtroom itself has found that he should not be able to represent himself. And at which point I would find that this motion is entirely inappropriate because it's already been ruled on before.
All right, so
Behind your butt, Judge.
no, Mr. Blandino. All right, Miss.
I object to that.
I'll hear from you, Mr. Gersten, because it sounds from what I'm hearing about what happened in district court and then this court with Judge Sacento and then Judge Bradford that there's a strong law of the case that you should remain as counsel. However, there's the countervailing balance here is that he satisfied all requirements. There's no suspended sentence. So ordinarily, somebody in that situation wouldn't be entitled to appointed counsel. So I'll hear from you as I'm sort of balancing those two.
I'll as basic as I can say it. So yes, at some point during all three cases that I've represented him, the court has come back and said he is to be represented by counsel. They denied the Ferretta canvas, etc. The issue in all those cases was, as he mentioned, that was all pre-trial. So we're after that at this point, and he is not under any jeopardy at this point. So, I'll just say to you what I've said to all the courts. Whatever you want me to do, I will do. I know that he wants to represent himself. I don't think he's done half a bad job today. I think he's been, fairly good in his representation.
Zach, I feel your pain. I do. Sometimes I talk in here as other people. And then I have to delete it real quick before anybody sees.
But again, I serve the court's pleasure. And I will add one other thing, that when it came time, even though the case was over and the case was, he needed the order for his property, I did reach out to the Office of Appointed Counsel to make sure I could do that, and they did give me permission to handle the case through the this issue, even though he could technically have his own counsel. So it really does come down to you, Your Honor. Whatever you'd like to do.
Okay.
I stand.
All right. So no, Mr. Blandino, I've heard from the state. I've heard from you. I've heard from Mr. Gersten. At this point, I am very reluctant to disturb what has been done by my count, at least 3 other judicial officers. So I will deny the motion for substitution of counsel. We have a briefing schedule as far as a renewed motion for return of property, and hopefully we can get it resolved so we can have some certainty as to what's going to happen with these passports.
Thank you, Your Honor.
Yes.
Thank you, Your Honor.
It's gonna be May 19th at 8:30.
May 19th at 8:30?
Yes.
And that is for the hearing?
That's the
Is
hearing.
the motion due April 28th then?
April 28th and then May 12th.
Thank you.
And then just, Your Honor, for the record, could we order the transcript?
Yes.
for Mr. Blandino?
Yes.
Yes. Can I get the jazz too, Judge?
You're gonna have to put an order in the clerk's office for the jabs.
I will.
No, I'm just telling you.
Can I get them without expense since I am having forced counsel? I believe it should have that cost as well. Because I think this is an appealable issue. You've got no basis whatsoever to appoint counsel.
I'm representing you now, so stop.
All right.
Thank you, Your Honor.
So, Mr. Gerson, I will order transcripts, and however we're going to get jabs, you can submit the proper paperwork.
Thank you, appreciate it. Thank you.
Thanks, Judge.
All right. Have a good day.
Okay, before we move on, remember, everything I just showed you up until this point has been covered way better by Law Talk with Mike. The full things. And like I said, he even had Blandino on his show. He was speaking to him. It was great. So, if you want to dive into this pit of Kim Blandino, it's worth it. High quality content. Go to Law Talk with Mike. Watch it. If you don't want to go there, you can go to Our Nevada Judges. Watch it there. There's one more channel I know that has it, but we don't talk about that channel. So, pick one of those two if you're going to watch it all. I suggest watching it all. It's so good. Now, I'm not sure if Law Talk with Mike covered this hearing that was this month. It was 12/2. Okay? But 12 days ago, Kim Blandino uploaded this one video on his own channel called Kim Blandino. So that brings his total up to 6 videos he has on his channel now. And I think it's the actual Kim Blandino, because there's a short on the channel where Kim Blandino is carrying a sink into a courthouse like Elon Musk did. So I think it really is his channel. He's only got 49 subscribers, and only one of his videos got over 1,000 views, which is crazy to me. Because if it really is Kim Blandino's channel, which I really believe it is, I think he should have way more subscribers. Did I subscribe? No. I didn't. I maybe should have, but YouTube will tell me if I need to do anything. It's all right. So this, thank you, Zach. You understand. So this hearing we're about to see is 17 minutes long, so it's going to push us over the 2-hour mark. It's fine. We'll live. And this is his latest on trying to get those darn passports. Remember we saw in March him saying, I just want my passports. So this is sort of a continuation of that. He still doesn't have his passports. He made it to 150 subs now, Zach. You never stop giving. All right, here we go. Oh, Tina's on a streak. Tina's on a major streak in Twitch. Thank you, Tina.
9-W Kim Blandino versus LVMPD.
Kim Blandino appearing pro se for Kim Blandino.
Good morning, Your Honor. Matthew Christian for the Las Vegas Metropolitan Police Department.
Okay, Mr. Blandino, I did not receive any information that you had served the Metro Police Department. Mr. Christian is here, though, so you received notice.
We've at least received actual notice. I know Mr. Blandino's been by headquarters.
Okay.
And he's made many phone calls to my assistant.
Okay.
So that's why I'm here, and I apologize I haven't been able to get anything on file. But
Okay.
I'm very familiar with these passports because we've worked in court on them once before.
All right. So, just a minute, Mr. Blandino. So, you have not filed anything yet. Is it your contention you have not been formally served with the motion practice or the orders of the court?
I haven't looked into that very closely, Your Honor, but I would not be surprised if there are procedural problems with the initiation of this lawsuit.
Okay. All right. Mr. Blandino, so the issue I have is under the rules, whenever you file a lawsuit against somebody, you're required to also file proof of service.
I did.
You did not file proof of service. If you served them that's one thing, but you did not file proof of service in the court. So there's nothing on the record that I look at and says, I served Metro.
But this really isn't a lawsuit, it's a petition for writ of habeas corpus. The vexatious litigant order requires me to pass it by the chief judge. Have you taken judicial notice, or you're aware of the vexatious litigant order in this case, right?
No, I am not. I haven't seen that either.
Okay, well, it was submitted to Judge Weiss, and then he granted it. Now, it's in the alternative form. It's a petition for writ of habeas corpus, or in the alternative for prohibition, the alternative for mandamus, and the alternative for certiorari, and the alternative for whatever combination the judge deems it. So I'm a petitioner in this case. I studied the case law for months because there was an order down in the Justice Court, and I attached that as an exhibit, that property was to be returned to me. I went there with a certified copy to the vault, and they refused to give it to me. And I said, got the name, the badge numbers, the people refused. LVMPD comes into court. Well, procedurally, the district attorney had the audacity to go ahead and represent LVMPD in the Justice Court. And I objected to that, and then he didn't do that again. Subsequently, Matthew Christian came in and said, oh, it's contraband. He contacts the embassy in Israel. I am not. Those passports are not of the state of Israel, nor do they import to be. This is the flag of the state of Israel. This is the flag I fly where I stay, and it is a consulate. This is the Kingdom of Israel flag here, which you'll notice has the Star of David with the cross on the inside. My king is Jesus Christ, otherwise known as Elohim. It's the singular, it's the plural. With your background as a missionary, which you publicized throughout the media, you would know that Jesus Christ is a recognized historical and religious figure throughout the entire world. So there's no way that these passports are contraband. I mean,
So I just want to back up a little bit. So I was just talking about notice here, and so before I do anything in any case, regardless of how you're classifying it, not as you're saying it's not a lawsuit,
right?
Right. So just let me finish. The issue I'm trying to say is that you need to file under the rules. Once you give notice to them, then you have to file in my court. In this case, you have to say under this rule that you have given notice.
They waive service of process under both the Nevada rules and the federal rules. We are required, litigants that is, are required to reduce the cost. In Nevada, it's Rule 4.1D, I believe, and then in the federal practice, waiver. Now, he's in the same office where risk management is. When I have 2 lawsuits that are pending appeals.
So we're moving away from my question, but you didn't. So, but you still need to, in my case, file something that says waiver. They waived service of process. So the issue is right. So when I make a decision, I need to, because we're having this hearing today, because I've already received your motions, but I have not seen on the record that there is proof that they received notice. Now they're here today. So now I know that they have notice. Right. So they have notice of it, but I can't make any decisions until they have the opportunity to respond to that, until they have notice. And so when you file something in the case, it needs to also say, by the way, it was served. So usually a motion will have a certificate of service attached to it. But in the case of an initiating document, you need to file what's called an affidavit of service. And so I don't have either of those things for this motion.
That's true, and it's a clerical error on my part. I should have filed with it an affidavit and a separation in my case, because I can't swear or affirm under my religious beliefs and practices.
Right. So the issue then.
Of waiver of service. But here's
so the simple thing is, today I cannot make a decision.
No, I understand.
So I'm just trying to save everybody time today, because whatever happened, I understand your side of it. I received your motion. I understand the difference between Kingdom of Israel and the State of Israel. I understand that 100%. Okay? So, but what I'm just trying to tell you is I'm not going to make a decision today. I needed to talk to, I did not expect the Metro to show up today, because on the record, I have no proof that they've received notice. But now that I understand that they've received notice, I'm just going to put them on a timeline to respond, and we need to come back here because they get to file their response.
If I may, there's some matters that are really troubling to me in this case.
Okay?
As the counsel for LVMP mentioned, that I had made numerous
I have
calls.
no
didn't
problem
get a call
swearing.
for one.
None.
And when you do an emergency motion to the federal courts, I know it's different in the state, it's different with the Nevada Supreme Court than it is with the district courts. But there's always that meet and confer obligation on the part of the parties. And he has an obligation as an officer of the court and representing his clients to get in touch with me and say, hey, what are you looking for? Is there any way? And, you know, I did do an administrative demand. One thing I would like to get on the record here today in some fashion is I did call the vault and talk to Julie. I gave her badge number down at the vault, and she said administratively they have held the destruction of that property till November of next year.
Okay.
But that doesn't mean I can depend on that, Judge. If there's a fire or somebody mistakenly takes one file, clerical errors happen all the time. Files get destroyed, transcripts get lost. I mean, the history of cases in Nevada show all this kind of thing. But to not even call and meet and confer is just sloppy practice. I think the court, it would be proper to admonish them, because if they wanted to try and resolve this in good faith, which appears they don't, then they should at least contact and consult with me. I can talk on the phone or email. I've gone down to the building personally, and I served them personally with some documents. The other thing that's really important here
So before you move on, let me address meet and confer. Meet and confer is a requirement for discovery matters.
No, on emergency matters as well.
In our court, it's a requirement for discovery matters. So when you're in litigation, when you're making a motion, they get to respond to the motion. However, they have no obligation to engage in this litigation until they receive proper service of process. That's from the United States Supreme Court. So we have to wait until they get, so if they've waived it, there's a process to waive. It's not, hey, they're a state entity or they're a arm of the state, so they waive process. That's not the way waiver of service works. They have to formally say, we are waiving service of process. That gives them more time to respond. It saves you costs, but there is a process for doing that. So once again, I don't have that document in front of me because it's not been filed. You say it's a clerical error. That's great. I understand that. So what I want to do today is give time. I've given you your injunction, and from what they tell you, they're not going to destroy the documents at this time. So I need to give them time to respond. That's all we're talking about today. And when we come back, we can get into the substance of the arguments. But we're not going to get it resolved today, so I don't want to get in.
Administratively, though, it's important, is there was a motion for reconsideration because.
Where? In front of the Justice Court?
Here.
Reconsideration?
It's set for December 30, as the calendar stands right now.
The reconsideration on the bond issue? I thought I dealt with
Yeah, on the
that.
bond issue as well as some of the things that came through on the thing, because I didn't get service of that order where you inserted language into my order for shortening time. So I just looked at it on the computer. I can't see it because I don't have attorney portal.
Okay.
Unless I go down to the district court, and that's when I found out. I'd rushed down here that same day. You gave me that day, once I found out, to post that $250 bond, which I did. And then I put in an emergency motion for reconsideration.
Right.
And I did email them copies of this stuff.
Right.
And so, but the thing is that motion for reconsideration, are we going to maintain that December 30 calendar date?
I thought I had already dealt with that. I'm not reconsidering the motion. I issued another minute order. Did you get my subsequent minute order?
See, that's the thing. Tyler Technologies, apparently, which is a subcontractor for the county, apparently is not getting this stuff out.
Okay.
In fact, they routinely, in my email, they must acknowledge they have problems because they send back-to-back duplicate emails to make sure you at least get one, but in some cases, I'm not getting what I'm supposed to be getting.
Okay. Well, I'll double check that. If my understanding is we already sent out an order, but I'll double check that. Okay. As to the
Well,
December
I can
30th.
get it. But going forward, you know, this is important to me because this was not, and I got to reiterate, this, I do not want this court to treat this as a mere lawsuit, because then latches could come into play and everything. I'm merely trying to do a habeas corpus. Those things were taken this September 16 of 2022. That means over 3 years now they've had these IDs. They did not prosecute. They dismissed in the Justice Court for the preliminary hearing, before the preliminary hearing, for felony charges. I mean, they're totally bogus. They denied and then dismissed because there's 2 original passports there. But the thing is that it is habeas corpus, I believe, and not as a lawsuit, because once I get that property back and it's determined not to be contraband, then I will be able to, if I choose to, if they won't settle, then I could file a federal suit or a state suit for the property that's been wrongfully detained. And so if you treat this as it were a lawsuit, then we could have, oh, well, this is just duplicative. You know, I've had the federal court throw that stuff at me, that it's duplicative. Now, Judge Weiss, the chief judge, already made the threshold decision. He could have said, no, I'm not filing this as a habeas corpus.
So you're getting into the merits right now.
No, I'm just getting it. I think it's procedural, because this is a petition to read it.
I'm not making any decisions today about your case. That's why I keep on trying to tell you. So I'm just giving you additional time at this time.
When you call me the plaintiff in a suit, you're treating this as though it is.
I can call you the petitioner if you want.
I'd appreciate that.
Okay. So,
We do have
Mr.
a
Christian,
December 30 date. Can your clerks confirm that there is a date for that on the calendar?
just a moment. They'll look at that while I'm talking to Mr. Christian. Mr. Christian, how much time do you need to file a response to what is in this court?
2 weeks.
Okay. Mr. Blandino, would you like to be able to file a reply to whatever he files before you come to court, or do you want to come to court just after he files his response? Typically, you're allowed a reply, but it's based on you, how fast you want to
You're going to
move.
set this for hearing. Did you want to set?
Well, it depends on whether or not you want to file a reply. That's why I'm asking you. He wants 2 weeks. Would you, typically you get 1 week for a reply if you want it, or we can go to a hearing in a week if you'd rather move more quickly to a hearing without a reply.
You could set a hearing in a week then? Is that an option?
After, I'm going to give him 2 weeks for his brief, and then after he's filed his brief, I can do 7 days after that, or if you want 7 days to file a reply, I can wait for you to file a reply and give you another 7 days to come in for a hearing.
Well, because this is an emergency matter to me, and I know the courts never really define exactly what emergency is. I'm 70 years old. I could drop dead in 2 weeks. God could take
Let's
me
hope
right
not.
Huh?
Let's hope not.
I'm sincerely praying that. But so, because it is, then you're asking whether I want to waive filing a reply then? Is that?
Yeah.
Okay. All right, because it's an emergency matter, I've already submitted there. I'm waiving filing a formal reply then, but I
Okay.
would reserve the right to argue in reply here when we got there. Our
Your
next
Honor,
hearing.
coincidentally, I do believe I have another matter in Your Honor's courtroom on December 30th.
Okay.
So I don't mind having it be on December 30th.
So we'll do a hearing on December 30th at 9 a.m.
Well, in that case, I've got an opportunity to file a reply then,
Sure.
since that's new information here. Okay.
Sure.
Well, then I'll.
So you'll do your opposition by the 16th, the reply by the 23rd, and this will be set for a hearing on the 30th.
Perfect.
All right.
I'm sorry, what was the 23rd is when my replies due?
The 23rd is when your reply is due. Just by midnight, it needs to be filed.
Okay.
Okay. All right, and we'll see you the
I will
30th.
check with the clerk on that service issue, because this is a real concern. I was in the clerk's office and they're having some problems there. Tyler sent me emails saying they've had problems and they've had to redo the system somehow. So
Okay.
it's very concerning to me. I'll go to the clerk's office and see if I can get that order.
All right,
But
thank
I
you.
apologize for, I should have submitted a waiver of formal service of process.
All right.
I apologize for that.
Thank you, Mr. Randolino. Thank you, Mr.
One last
Christian.
thing, could I was in form of papyrus down below, and
Every new case, you need to get a new informer papyrus.
I can't get a copy of the transcript?
Judge Weiss is the one who does that.
Okay.
So, a copy of this transcript today? You just need to order it. But if you're informer papyrus, it's different. You don't have informer papyrus in my court yet.
You want me to file for informal buffer status here then?
If you want your transcript for free, yes. So, but Judge Weiss is the one who decides that. Okay?
One last thing, Judge, is the court amenable to taking judicial notice of the fact that that order has not lost its vitality in the Justice Court? The order to return the property is still active and alive.
You can put it there in your reply. You can file it before me and ask me to take judicial notice of it in your reply if you want.
Yeah, the one thing connected to that is Judge Bradford would not sign the order until LVMPD gave a reply in 10 days. She gave me 10 days. I had the order before the 10 days was up. They didn't respond, and they therefore really have waived right to object in any manner. This is egregious that I have to go through this procedure just to get my property back.
Okay. Thank you.
Thanks, Judge.
Yeah, we made it to Kim Blandino. We made it to the end. Whoo! Look, that was a small taste. His content is so good. He is the poster boy of what you just never should do in court, ever, ever, ever. And then he keeps going to jail over these cases. And I don't know, it just, whew. There was another Blandino that just popped up on our Nevada judges this past week, Zach says. And Zach would know. So, our Nevada judge is just great. It's just absolutely a fantastic channel all around, and it has been for years. Years. So, we made it through today with a few technical issues that we overcame. But really, my computer probably was just upset that I was forcing it to play Blandino again. Because, I had to get the clip. Then I edited the clip. Then I had to play it for the third time, and my computer was like, stop it now. This can't take no more. He's a mess, and there was no stopping point. There's just no stopping. Monday's great for me, Zach. Oh, but not for my computer. Monday's great for me because I have off work, which means my computer gets pounded on. It's time for my computer to wake up and get to work. We got stuff to do. We got lots of stuff to do. Okay. Speaking of lots of stuff to do, oh my gosh. It's time for OJ finally. Oh man, it's been 2 days. We didn't stream yesterday because I'm lazy. I'm sorry. I just didn't stream yesterday. No, I was not anywhere at 4:30 in the morning. I was in my house. I could have just walked to my computer and streamed. I could have. But I could not wake up. I couldn't wake up. I couldn't. I slept. I got off work whenever. And then I slept until I had to rush into the shower as fast as possible before I started work yesterday. I didn't eat. I stopped playing video games on my phone 5 days ago because my thumb, it needs a rest. It needs a rest. It needs that tendon to relax. It's being a total diva right now. So I couldn't do that. If you can't play on your phone at night, what else is there to do? So T, my sister, there is a big gulp cup like in the side of my house. Nobody here drinks big gulps. I don't know how it got there. So I don't know the answer to that, T. I could be making, the wind could have, it was very windy. The wind could have blew it from any other neighbor, maybe. Never happened before. And it's way down at the side of my house. It's not like at the front of my house. But, I don't know. That big gulp cup, I don't know. I am probably making something out of nothing. I do that sometimes, it just happens. So, I don't know. It's just one day at a time, right? We're all going through one day at a time for all kinds of stuff. Nothing happened today. Nothing bad happened today. Yeah, I'm making molehills out of mountains. I would love to have a little mole. They would be so cute. Oh, my cats would not, though. Can't have nothing good because of these cats. But they're so darn cute, my kitties. Except for that one. I have one cat I call Methany. Because she's a total spaz. Total spaz. And I don't know what to do with her. She's not cuddly. She's not nice. She's not anything, a normal cat is. She, like when you walk into a room, she gets both very angry and very excited at the same time. And then she starts meowing. Okay. Cat meowing. I go over to her, talk real nice. Hi, Meth. Hi, Meth. And I put my hand out, and I don't pet her. I let her decide. So I put my hand out, talking to her nice. And then she comes up angrily, and she butts her head into my hand. And then she shoves her whole body up against my hand. But then she meows and growls while she's, like, trying to get pet. So I pet her, and the purring, loud purring starts almost immediately. However, I don't think this is happy purrs. I think this is extreme stress purrs. Like, she wants to be petted so badly that she gets excited, purrs, meow. She shoves her body up against your hand. And then you, like, pet her twice, and she, like, runs 5 feet away. And then she starts meowing at you like you just did something really bad to her, which you didn't. I basically stand there like this. I don't even barely move. I barely pet her. I let her pet herself on my hand. But she gets so mad at me, and then she, like, meows, like, how dare you? But then she starts meowing again, and she runs closer. My hand's still out. I'm still talking to her. She runs closer, and she pets herself violently. She's like, psh, psh, and then she runs away. So, I don't suggest you do this next part ever. 2 nights ago, she was extremely agitated because I was feeding her. And she wanted that food so bad. But she did not like the fact that I was feeding her. She was angry about that, but she wanted it so bad. And she was like having an episode. Like, she was highly agitated and meowing, and she wanted the food so bad. She didn't want me, so I picked her up and I sort of held her still for just a minute. I'm like, okay, you need to relax. You need to calm down. You need to realize I am never going to hurt you in a million years. I will never hurt you. So I, like, held her real close, talked real soft, and was petting her to try to get her to just stop for just a second, flipping out so she can eat her food. So it was just for, like, I don't know, 40 seconds, 60 seconds tops. I held her, pet her, talked to her real soft, and then put her in front of the food, and then I just walked away. I don't know what happened. I don't know if she ever got to her food, if she ever calmed down. I knew I had to leave the room for her because I overexcited her, apparently. Yeah, I should give her some gummies, but she won't. She won't take anything from me. She wants to. So bad. But she gets mad because she wants to. Methany. That's all I can say. But she's so cute. She's calico. So she's every color. Every color you can think about. Her white is spectacularly white. Her orange is such a bright orange. She is gorgeous. She's a gorgeous cat. And she's tiny, which makes her just even more cute. And her meow is so cute and forceful. But I gotta get in good with this cat. Me and this cat have to figure it out. It just takes time. I will try to get her stuff. Yeah, I have these brushes that you put on the corners of walls. They stick there that the cats rub up against. And I have lots of cardboard they can scratch, and I have rope. I like hot glued rope on wood so they can scratch. I even have squares of carpets going up the wall so they can reach up and scratch, or they can climb up. There's little ledges at the top of the carpets. And then I have all these games for them to play, like, you know, like, it's only this big, it's a box on the floor and has some balls in it that they're able to get out. Their balls aren't, like, stuck in there to frustrate them. But there's these little weird shaped holes in the top, so they have to reach their paws in and try to get the balls and, you know, knock them around, and they bounce, they get to play. And I have these little things on the doorknobs, or if you, it's like a cat with a tail coming down, and if you press the nose with the cat for like 5 minutes, the tail starts swinging around wildly. And I have laser lights that I always end on food or treats. I don't just let them chase it for an hour and then say, okay. I always end it on a treat, so they actually catch something in the end. I got strings that hang from my doorways, like stretchy elastic, and there were specific toys on them, but they always take the toys off. It's like fishing, where they always just take the bait. My cats have taken every single toy. The string keeps getting higher and higher and higher because I have to tie a different toy on there. But that's like days of fun. They do not just play with that a little bit. When there's something against your door and you're trying to sleep, they will play with that for hours. And it'll keep scratching and banging against my door. I don't care. They're having fun. It is quite annoying, though. It does get quite annoying. There's no toy right now on my door because they keep taking it. Oh. Methany bites. Not hard or anything. She has so much emotion in her. She has to get it out. She doesn't draw blood or anything. She just, you put your hand out. She pets herself and then she gets mad at you. But she would never hurt me or anything. I don't have a cat that will hurt me. Well, that's not true. I think Lafayette's really trying to kill me. I really think so. It's like almost every night I wake up with him on my face, like covering my face, laying across my face. Like if I don't stream tomorrow morning, it's because Lafayette strangled me while I was sleeping, and I just slept through it. I think he's trying to kill me, but he purrs so loud it wakes me up. Anyway, I gotta go. I gotta start. Oh my gosh. OJ starts now. Oh, it's getting so good. Bye, guys. You guys have a great day. Thanks for coming out. I'll see you soon.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun. her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.